Okay. The next one we call it as preventive detention. Article yadappa? It is Article 22. Article 22. Now, what does Article 22 talks about? It is Article 22 talks about. ಇಲ್ಲಿ ನೋಡಿ ನೀವೇನು ಓದಿದ್ರೆ ಅದೆಲ್ಲ ವೇಸ್ಟ್ ಇವಾಗ, ಬಿಕಾಸ್ ಎಲ್ಲ ಅಪ್ಡೇಷನ್ ಆಗಿದೆ, ಜಡ್ಜ್ಮೆಂಟ್ ಬಂದಿದೆ ಈಗ. ನಾವು ಸರ್ ಆರ್ಟಿಕಲ್ 22 talks about, ಅದಕ್ಕೆ ಒಂದು ನಿಮಿಷ ಬ್ರೇಕ್ ತಗೊಳ್ಳಿ ಅಂದಿದ್ದು, ಬಿಕಾಸ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್. ನಾವು ಆರ್ಟಿಕಲ್ 22 talks about arrest and detention. It talks about two types of, I can say, arrest and two types of detention. One we call it as it is punitive detention. ಅದು ಮುಗಿಸ್ಕೊಂಡು ಅದಕ್ಕೋಸ್ಕರ ಅದಾದ್ಮೇಲೆ ಪ್ರಿವೆಂಟಿವ್ ನೋಡೋಣ. ನಾವು ಸರ್ ಪ್ಯೂನಿಟಿವ್ ಅಂದ್ರೆ ಏನು ಸರ್ ಅಂತ ಕೇಳಿದ್ರೆ, ಥಿಂಕ್ ದಾಟ್ ನಾನು ಯಾರನ್ನೋ ಚುಚ್ಚಿಬಿಟ್ಟೆ, ನಾವು ಚುಚ್ಚಾದ ಮೇಲೆ ನೀನು ಚುಚ್ಚಿಲ್ಲ, ಓಕೆ, ಯಾರನ್ನೋ it is punitive detention is nothing but after the offense has occurred. Now offense occur ಆದ್ಮೇಲೆ don't you think the police will arrest me? Now police arrest ಮಾಡಾದ್ಮೇಲೆ ಏನ್ ಮಾಡ್ಬೇಕಿಲ್ಲಿ? Nothing but within 24 hours. It is, see, first thing ಏನಪ್ಪಾ ಅಂದ್ರೆ, it is arrest ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆ they need to get a arrest warrant. ಇವೆಲ್ಲ ನಿಮ್ಗೆ ಗೊತ್ತಿದೆ ಅನ್ಕೊಂಡು ಆಲ್ರೆಡಿ, arrest warrant. And second one, they need to inform on what grounds I have been arrested. Saying ಇಲ್ಲ ಅದ್ ಬಿಟ್ಬಿಟ್ಟು ಬಾಬಾ ಅದ ಗಾಡಿ ಅಂದ್ರೆ no, it is nothing but you need to give up, or you need to give up, I can say, exact the reason for arrest. The third one after I can say arrest, it is within 24 hours ಅಲ್ಲಿ, it is within 24 hours we need to produce before the nearest magistrate. ಅದು ಬಿಟ್ಬಿಟ್ಟು ಸಿಕ್ಕಿಮಲ್ಲಿ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ಬೆಂಗಳೂರಲ್ಲಿ ಪ್ರೆಸೆಂಟ್ ಮಾಡೋದಲ್ಲ, nothing but nearest magistrate within 24 hours, excluding traveling time. It is excluding traveling that time. Last one we call it as it is after ಏನಾದ್ರೂ ಸೆಂಟೆನ್ಸ್ ಮಾಡಿ ಅಂತಂದ್ರೆ ಆಬ್ವಿಯಸ್ಲಿ ಏನ್ ಮಾಡ್ತೀವಿ ನಾವು, automatically we'll be sending it to ಎಲ್ಲಿಗೆ, it is either prison or to the jail, or you can say either police station or to the, it is judicial ಇದಕ್ಕೆ. Yes, ಇದು ನಿಮ್ಗೆ ಆಲ್ರೆಡಿ ಗೊತ್ತಿದೆ, we call it as punitive detention. Okay na? Yes. The second one sir, preventive. Nothing that, for example, ಅಂದ್ರೆ ವಾಟಲ್ ನಾಗರಾಜ್ ತರ ಏನೋ ನಕರ್ ಮಾಡ್ತಾರೆ, ಬುರ್ಕಾಕ ಬರ್ತಾರೋ ಏನೋ ಗೊತ್ತಿಲ್ಲ, nothing but think that he is creating some problem, but ಇವಾಗ ವಯಸ್ಸಾಗಿದೆ ಸುಮ್ಮನೆ ಆಗಿದ್ದಾರೆ. Nothing that, sir, preventive detention ಅಂದ್ರೆ nothing but before occurrence of I can say an offense, I will be arresting a person. Now preventive detention is mentioned under which list? ಗೊತ್ತಿರಲಿ, it is mentioned under the concurrent list. Nothing but both the parliament as well as the state legislature as the authority. It is both parliament as well as the state legislature as the authority. Now parliament as the authority with respect to, it is national interest, whereas the state as the, I can say, state as the authority with respect to the state related issues. Now understand my word. Now preventive detention ಅಲ್ಲಿ it is arrest ಮಾಡಬೇಕಾದ್ರೆ, do I need warrant? Should I need to provide any reason? Should I need to, I can say, give an option to inform my lawyer? Should I need to produce before, I can say, magistrate within 24 hours? ಹೌದಾ? No, it is ಯಾವುದು ಇಲ್ಲ. Yes, all this are being excluded. Nothing but arrest ಮಾಡ್ಕೊಂಡು ಹೋಗಿ 6 ತಿಂಗಳವರೆಗೂ ಇಟ್ಕೋಬಹುದು ಮನೆಯಲ್ಲಿ. ಯಾವಾಗ? After 3 months. Hope you get what I'm saying. It is 3 months ವರೆಗೂ ಮುಲಾಜೆ ಇಲ್ಲ ಇರಬೇಕು. But for the first time, it is, sir, advisory board ಯಾವಾಗ ಬರುತ್ತೆ ಸರ್ ಅಂತ ಕೇಳಿದ್ರೆ, after 3 months ಆದ್ಮೇಲೆ 3 months ವರೆಗೂ nothing. But now for the first For the first time in the last year, the Supreme Court has provided a judgment saying that yadappa judgment anta kelidre it is Jashila Shajili. They have reversed all the constitutional principles. Saying that sir reason inform ಮಾಡಬೇಕಂದ್ರೆ yes. Now sir reason na inform ಮಾಡಬೇಕಾ ಅಂತಂದ್ರೆ ಎಷ್ಟು ದಿನದೊಳಗಡೆ ರೀಸನ್ ಆಗಿ ಇನ್ಫಾರ್ಮ್ ಮಾಡಬೇಕು ಅಂತ ಕೇಳಿದ್ರೆ as soon as possible on practical grounds. Nothing but reason ಕೊಡಬೇಕಾ? Yes. Nothing but as soon as possible on practical grounds. Practicality ಆದ್ರೆ ಆದಷ್ಟು ಬೇಗನೆ you need to inform the reason. You need to inform the reason. And second, okay sir reason ಹೇಳ್ದೆ, ಅರೆಸ್ಟ್ ಮಾಡಾದ್ಮೇಲೆ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ನಾಟ್ ರಿಕ್ವೈರ್ಡ್. ಬಟ್ ಏನಕ್ಕಪ್ಪ ಅರೆಸ್ಟ್ ಮಾಡಿದೀನಿ ಅಂತ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡಬೇಕು ವಿತ್ ವ್ಯಾಲಿಡ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ನಾವು ವ್ಯಾಲಿಡ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ದಟ್ ಅಮೌಂಟ್ಸ್ ಟು ವಾಟ್? That amounts to violation of Article 22. That amounts to violation of Article 22. And the third one, in case enadru falseful agi detain madidre, who will be punishable? It is the officer in charge of the detention. Officer in charge of the detention will be the punishable. Anta. Okay, alva? All those are the updations with respect to, I can say, the Supreme Court verdict in the landmark judgment we call it as Jashila Shaji versus Union of India judgment. Jashila Shaji versus Union of India judgment. They have clearly said reason ಕೊಡಬೇಕು. ಬಟ್ ಯಾವಾಗ ಸರ್ ಅಂತ ಕೇಳಿದ್ರೆ ಆನ್ ಪ್ರಾಕ್ಟಿಕಲ್ ಗ್ರೌಂಡ್ಸ್ ಆಸ್ ಸೂನ್ ಆಸ್ ಪಾಸಿಬಲ್. ಮೊದಲು ಹೇಳ್ಬೇಕಂತ ಹೇಳ್ತೀನಿ ನಾನು ಇಲ್ಲಿ. ನಥಿಂಗ್ ಬಟ್ ಆಸ್ ಸೂನ್ ಆಸ್ ಪಾಸಿಬಲ್ ಯು ಶುಡ್ ಇನ್ಫಾರ್ಮ್ ಏನಕ್ಕೆ ಮಾಡಿದೀವಿ ಅಂತ. ಸೆಕೆಂಡ್, ನಥಿಂಗ್ ಬಟ್ ಐ ಕ್ಯಾನ್ ಸೇ ಇಟ್ ಇಸ್ ಸರ್ ಡಾಕ್ಯುಮೆಂಟ್ ಸಬ್ಮಿಟ್ ಮಾಡಬೇಕಾ? ಎಸ್, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಯು ನೀಡ್ ಟು ಸಬ್ಮಿಟ್ ಆಸ್ ಸೂನ್ ಆಸ್ ಪಾಸಿಬಲ್ ಟು ದ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಆಲ್ಸೋ. Now without any documents, automatically that amounts to the violation of fundamental rights of individual, and that can also be punished the officer who have detained him. ಹೌದಾ ಇರೋ ಸರ್? ಏನಿ ಸರ್ ಈ ಒಂದು ಬೋಲ್ಡ್ ಇನಿಷಿಯೇಟಿವ್ ಬಂತು ಅಂತ ಕೇಳಿದ್ರೆ ರೀಸೆಂಟ್ ಆಗಿ ಅಟ್ ದ ಯೂನಿಯನ್ ಲೆವೆಲ್ ದೇರ್ ಹ್ಯಾಸ್ ಬೀನ್ ಡಿಟೈನಿಂಗ್ ಆಫ್ n number of, I can say, the opposition members of the ruling party. ಯಾರು ರೂಲಿಂಗ್ ಪಾರ್ಟಿ ಅಗೇನ್ಸ್ಟ್ ಅಪೋಸಿಟ್ ಮಾತಾಡಿದ್ರೆ we have arrested n number of personalities, including media personalities also. ಅವ್ರೇನ್ ಮಾಡಿದ್ರು? they have filed a case saying that there has been n number of illegal detention which is happening under the tenure of this against the ruling government. Give us some verdict. And they have said that okay, arrest ಮಾಡಿ ಬೇಡ ಅಂತಿಲ್ಲ, but give us the exact documents saying that how are they creating some law and order disturbance? How are they creating, I can say, we call it as it is national security issue, and how are they creating some disturbance also? Yes or no? Now ಎಲ್ಲದಕ್ಕೂ ಕೂಡ you need to give valid reasons, and valid reasons ಜೊತೆಗೆ, and you should also say that, and ಯಾವ ಒಂದು law ಮೂಲಕ you have declared, I can say preventive detention. Is it under UAPA? It is unlawful, I can say, Prevention Act of 1967, or with respect to national security, or Coffee Puza, or some other acts. It is mandatory agi you need to clearly mention. But in normal agadre I said 3 months, but even act alladre 6 ತಿಂಗಳವರೆಗೂ permission ಬೇಡ. It is for normal laws only. For normal laws only I have said it. It is up till 3 months. Whereas for all this, I can say acts only, we can extend it up till 6 months without the approval of High Court Committee. High Court Committee permission ಇಲ್ಲದೆ ನೀವು ಬದುಕಿದಿರೋ ಸತ್ತಿದಿರೋ ಅಂತಾನೂ ಗೊತ್ತಾಗಲ್ಲ, 6 ತಿಂಗಳು ಇಟ್ಕೋಬಹುದು. Yes or no? That is a dangerous act. We call it as preventive detention. Okay na? ಇವಾಗ ಹೇಳಿ, it is will the static help? 22 ಯೂಸ್ ಆಗಲ್ಲ ಈಗ, ಬಿಕಾಸ್ ಎಲ್ಲ ರಿವರ್ಸ್ ಆಯ್ತಲ್ವಾ? ಎಸ್ ಆರ್ ನೋ?